This is the matter of Stickinga versus Burns. Bronkema versus Becker. We're here on the defendant's motion regarding custody. Ms. Wagoner.
Thank you, Your Honor. I obviously am not the person who filed the motion, so I'm going to do my best to summarize what I understand to be the situation. There's an initial custody order that gave Mr. Stickinga full custody. At the time, my client was suffering from some mental health issues, and that was the reason for that decision. For the past 2 years, the child has resided virtually solely with my client. She has attended preschool and has started kindergarten with my client. Mr. Stickinga would come to visit on weekends. They would be sporadic and not consistent over the past 2 years. And in February, don't ask me where that came from. In September, he took her for a weekend visit, and it was my client's understanding that he planned to return her on Sunday. It was the end of September. And since that visit, he has not returned her. The child has had no communication with my client, has not been in school, had a doctor's appointment for a bump on her head that the doctors were concerned enough about that they wanted to get it scheduled. She missed that appointment. And my client is no relationship with her at the moment because she's not in her care. The only way she has even a clue as to where her child is due to an iPad that the child has with her. But for the past several days, she has not even been able to know where her location is. And so we are asking for, I think, a friend of the court referral for a custody investigation is appropriate, but also a order that returns the child to her care, gets her back in school where she should be, because now she has missed approximately 3 weeks of, albeit kindergarten, but still school, and she is required to be there, and awards Mr. Stickinga some parenting time on an every other weekend basis.
All right, Mr. Stickinga.
I have case numbers for Kent County and the Traverse City Police Department. Child pornography has been filed against Emma Burns, and I'm also filing for a motion to terminate her parenting immediately.
Well, you haven't done any of that, so.
No, sir, ma'am. Was trying to come up with the funds for the lawyer, and then I just couldn't. He wanted like $4,600, but he gave me all the paperwork and told me everything that I'm supposed to do until I can come up with the retainer to be able to pay for him to represent me.
Do you disagree that this child has been residing with Ms. Burns for the last 2 years?
I actually lived there for probably 9 months with them, both of them.
Okay, that wasn't my question. That wasn't my question. My question was, has the child been residing with her for the last 2 years?
Yes, ma'am, on and off. And
Okay.
part of the time I lived there with them, I was taking care of both of them pretty much. And like I said, with the open police reports and everything else that's going on right now, 1 second. He said,
I don't want to hear what your attorney told you. That's
I know.
privilege.
Yes, ma'am. Yes, ma'am.
Okay. And anything you tell me that somebody else said is hearsay at this point.
Yes, ma'am.
All right.
I want to figure out how to either get a continuance on the case so I can be properly represented, and with everything that's going on. I have proof, hospital records that she's not being neglected. CPS is involved. They came and did a wellness check. I have their phone numbers if you'd like to.
No, that is not my role.
Yes, ma'am.
So are you telling me that there is an ongoing CPS case investigating Ms. Burns at this point?
Yes, ma'am.
Okay. All right. Well, CPS.
I can give you the case numbers too if you'd like to.
I don't. You can give Ms. Wagner that information.
Yes, ma'am.
But at this point, it's clear to me that the established custodial environment based on the admissions with Mr. Stickinga or by Mr. Stickinga are with Ms. Burns. CPS certainly knows how to get an order from the court to remove a child based on abuse and neglect, which is what's being alleged. CPS has not done that. And parents cannot just take the law into their own hands the way Mr. Stickinga has done that. So I am going to grant the motion in order that this child be returned to Ms. Burns, pending an investigation by the friend of the court or action by CPS.
So So then what? I just go to the police station because like I said, it's an open investigation for child pornography against Miss Burns.
Sir, I'm not going to argue with you
It's not, I
at
have the
this
case
point.
number for you, ma'am. It's not an argument.
But that's also hearsay at this point.
No,
And
ma'am. We have officer of the law in
it's still,
Kent County,
sir,
in Traverse City County with case numbers.
again,
How is that?
CPS is the one to deal with that, and I'm not going to interfere with that investigation. But I am
How is that
I
hearsay though?
Sir, I don't have time to give you a legal education here, but I do. You're
You're trying
representing
to put my daughter back in the child pornography.
Mr. Stickinga. I am granting the motion, and we're adjourned. Thank you.
Your Honor, can we?
Ms. Wagner.
Have fun.
I just wanted it clear that he needs to return the child today.
Yes,
by 5 p.m.
that is the order that I'm entering, and law enforcement can assist. Both parties are present in the courtroom, along with Caleb Gonzalez, Assistant Prosecuting Attorney. Mr. Gonzalez.
Your Honor, this is not my motion. This is a motion to set aside the default judgment. But if it pleases the court, Your Honor, I do want to make a statement as to what's going on in this motion.
Please do.
So, Your Honor, I became aware that in this motion that the individual was receiving, the child was receiving state assistance. So the case was referred to us from the Office of Child Support. During that process, we continued to pursue this case as we were mandated to do by the state. And so it just became aware that the plaintiff at this time, the Branca Lisa, I believe, she was not, really, she was just strung along for the ride. She did not want a support. She just wanted to, continue to receive the state assistance that she was receiving. So she did get that state assistance, and we did pursue a judgment. So, Your Honor, I have no objection if the child is now living with the parent, if this judgment is set aside. I have no objection to that. And I just want to inform, the court and both individuals that we have to, I don't represent either party. I want to be fair to both parties, but we have to pursue child support when it's in the best interests of the state. And so sometimes that involves grandparents and forcing them forward to pursue that, even if it's against their will. So, Your Honor, I just want to let the court know that and to proceed accordingly.
Appreciate that. Ms. Becker, this is your motion. I have read it. Is there anything else you'd like to say?
I have nothing I want to say. Thank you.
Ms. Bronkema?
No, thank you. I'm all set.
Okay, then I will set aside the judgment.
Thank you.
All right, we're adjourned.
Thank you, Your Honor.
Thank you.
All right, good morning. This is the matter of Davis against Dixon, case number 25-005630DS. We're here on the prosecutor's motion for child support. Mr. Gonzalez.
Yes, Your Honor. If it pleases the court, I would like to put this matter on the record. A summons was issued on 6/25/2025. A proof of service was proper on or about 7/8/2025. The defendant answered on the same date. A pre-hearing conference was held on August 7th, 2025. A DocuSign was then sent on August 8th, 2025, and there was no signature on file, and there was no signature. So there was a bit of a delay. So with that said, Your Honor, both parties did agree. The plaintiff's net income was $1,743.72, imputed income of $13.35 hours a week, no additional children, 221 overnights. The medical share was 46% to 54%. The base support was $265, ordinary medical was $9, and the grand total was $274. The defendant's net income was $2,011.98, and he had actual income of $15 at 35 hours a week. Your Honor, I believe that is all the numbers. Oh,
Okay.
and let me see when And the effective date would be September 1st, 2025.
Thank you. Mr. Dixon, do you have any objection?
All that was correct. What we all talked about. Me and my child's mother have talked recently, agreeing to a different amount if that was something that we could do.
Mr. Gonzalez, is public assistance involved in this case?
I believe it is, Your Honor. Let me just make sure. Yes, Your Honor, I do believe that they have Medicaid, but not cash assistance.
Okay. All right. If there's no cash assistance, am I correct in that they could deviate from the child support formula if the court finds it would be unjust or inappropriate to impose it?
Yes, Your Honor, that is correct.
Okay. So, Mr. Dixon, why don't you go ahead and tell me what your agreement is?
Like I said, we usually have them about half and half. She has them about 4 days a week, 3 days a week. We both agreed that a price of $150 for now would be fine. It would work work perfectly for both of us financially.
Okay. Ms. Davis?
I did agree. We did have a conversation just based off what we're doing with our money, things like that, and where is that all going for the both of us. We did agree on the $150 price. Kyan goes with Dad for the weekend. I keep Kyan through the weekday, so we're pretty set on who has Kyan which days. We kind of just been going back and forth about, if that was okay, if we could come to you guys and get that price changed for him, for us, for the better, just because of financial ability. But I do agree with the price that he's saying.
Okay. Can you just very briefly basically say why you're willing to accept less than what the child support formula calls for?
I do work as well. I recently just kind of changed my job, so I'm able to kind of help out as well. I know our jobs are pretty straightforward, so I just think it's best financially for us we can lower it down for him, just for him to still be able to afford his living as well.
Okay. And you believe that you can support your child on that amount of contribution from him?
Yes, ma'am.
Okay. Does he contribute anything besides, does he contribute anything on top of that?
Yes, ma'am. If I can call child's father, I can always ask him for things that I need for Kyan, whether that's wipes, diapers, childcare, things
Okay.
of that.
Okay. All right. Thank you. Mr. Gonzalez,
Yes, Your Honor.
any comment about the requested deviation?
Yeah, so you said that you're more 50-50. Are you getting 182 days now a month for each party? And you did state the fact that you did change in employment. So if your wages changed, I would just like the order to reflect that your income has increased. I did impute you, but if your actual income, if you can just state how much you make per hour, and how many hours you're working, and then how many new overnights now that you have, I can change the uniform child support order to reflect that, and I can also do an addendum if necessary to change them out to 150.
Yes, so my job did change. Unfortunately, it's a decrease in amount. I work as a hostess or part server, so it's $2 an hour plus tips. The days that I host is $8 plus the tips.
So $8 plus tips, you usually have to get at least up to minimum wage. Are you telling me that you're not making minimum wage now, or you're still making $13 an hour?
No, I'm not making $13 an hour. That was at my previous job. So my base pay is $8 an hour plus tips. But I just became a server at my job, so it kind of varies. But
Okay, on average, because I know that as a server, you can't make below minimum wage, or they would have to pay you up to the minimum wage. So as a server, are you making a little bit above that, where you're making $8 plus tips? How much are you averaging an hour for work with your tips?
I would say definitely probably $8 an hour total.
$8 an hour total?
Because
Okay.
it really just depends on the night. I really can't give you a base amount because it really depends on the day, and it's kind of hard to put it on that on average.
Okay. So with that said, how much are you making? I mean, are you the overnights, have they changed, or is it above the 144 or the 200 and 221 that you have and the 144 that Randy has?
Sounds about the same. Because he works a
Okay.
full-time job, I keep Kion from Monday through Friday morning, and and I drop Kion off Friday morning. He goes with dad until Sunday morning. So
Well, I'll just so you know, I'll probably keep you at the imputed $13 an hour amount, and I'll just not just do an addendum for the 150. Okay, thank you, Your Honor.
All right. Yeah, and the court will find that it would be unjust or inappropriate to impose the child support formula amount based upon the contributions that Ms. Davis stated Mr. Dixon is making outside of child support. So, anything further?
Oh, no, Your Honor. Thank you.
All right. Thank you. We're adjourned.